Alright guys, so today we're starting our Introduction to Trust series. We're starting with the Commonwealth Caribbean Law series by Gilbert Codeline and Trevor Carmichael, Commonwealth Caribbean Trust Law. This is the second edition. To the work of Lord Wilberforce, a distinguished English judge with a Caribbean conscience. Alright, we have a foreword by Sir Ashley Roy Marshall. KTCBE MA CANTAB PhD LOND HON LLD Sheffield Barrister at Law in a Temple Distinguished Author Theobald on Wills Nathan and Marshall on Trust. The publication of Commonwealth Caribbean Trust Law is an important and gratifying step in the development of Commonwealth Caribbean legal education and research. When the Faculty of Law and the Council of Legal Education were established in 1970 and 1971 respectively, it was expected that they would provide the stimulus for furthering the high standards set for the region by the Federal Supreme Court, whose all too short life ended when the Federation of the West Indies collapsed. That expectation has been amply justified. The education which students receive in the course of their academic and professional studies serves them well in their subsequent careers. The existence of first-class libraries at the law faculty and law schools facilitates the search for relevant authorities from legal systems throughout the Commonwealth and beyond. It also meets the increasing demand for specialization, which is necessary to cope with the complexities of modern international relations in a variety of fields. The list includes trade and commerce, economics and finance, politics and diplomacy, globalization and multinational corporations, the environment and natural resources, and aid and development. Equally as important, available library resources enable the search for legislative solutions to all these problems to be focused on best practice wherever it is to be found. It is in this context that Commonwealth Caribbean Trust Law is such an impressive and important piece of work. Its strength lies in the combination of academic and practical expertise and experience of its authors. Professor Gilbert Codeline and Dr. Trevor Carmichael, the range of topics it covers and the wealth of source material it draws upon. Of practical importance is the material dealing with offshore trusts and their derivatives and the issues concerning their confidentiality, regulation, protection, and taxation. Commonwealth Caribbean Trust Law is essential reading for academic and practicing lawyers, accountants, and officers of government departments and agencies, banks, and financial institutions. The authors are to be warmly congratulated on the scope of their work, the clarity of their exposition, and the depth of their insights. This foreword was done by Roy Marshall Evanstone, Nelson Road, Christ Church, Barbados. Alright, so the preface. I like to read the forewords to get a feel for, the author and the information that you're gonna get in the books. I like to read the preface and the acknowledgements and the forewords and things. So the preface. The law of trusts is an area of growing importance in the Commonwealth Caribbean. Several islands in the region have developed or are in the process of developing facilities for offshore financial services and trust management, which has led to a great increase in the number of trusts established in those jurisdictions. In addition, economic development throughout the Caribbean has brought into focus such diverse aspects of trust law as the nature of beneficial interests in the matrimonial or family home, donationis mortis causa, charitable trusts, pension scheme trusts, and the fiduciary duties of trustees. Many Caribbean jurisdictions have also implemented specialist offshore trust legislation, which seeks to make the trust a more attractive instrument for persons outside the jurisdiction. While this new development is complex and dynamic, we have sought to introduce it into this new edition in a multi-layered sense, so that the reader may be able to appreciate an integrated perspective on the subject. The aim of this book is to provide a basic text for students of trust law in the Commonwealth Caribbean by means of an account of general principles, accompanied by analysis of selected Caribbean and English cases, both reported and unreported, which best illustrate the application of trust principles and which deal with the kinds of issues or issue which are most likely to be encountered in the Caribbean. It is hoped that practitioners will also find the book useful as a work of ready reference, particularly with respect to the unreported judgments which might otherwise be unavailable or inaccessible. We are extremely grateful to persons who have assisted with the previous edition, and particularly to Vanessa Codeline, whose legal and editorial skills were again of great value in research. Adrian Murphy also provided us with useful editorial suggestions, and Keisha Hyde assisted us with case notes and indexing. Colleagues at Chancery Chambers in Barbados were also very helpful and encouraging in a variety of ways. We would also like to thank the editorial staff at Cavendish Publishing Limited for delivering a most attractive finished product, and to extend special gratitude to Sir Roy Marshall for his very insightful and generous foreword. So this preface is from Gilbert Codeline and Trevor A. Carmichael, Bridgetown, Barbados, February 2002. And we must remember, guys, that Trinidad and Tobago and the Caribbean is a young nation. And trusts and uses has been around hundreds of years. So it is important to keep that in mind as we go through this book, because we will be going through other older books from countries that are much more advanced and knowledgeable on trust. So we will see the comparison so that we'll get a much more in-depth understanding and overstanding of trusts and how they apply. So we have the table of contents. So chapter 1 talks about the development and nature of trusts. Chapter 2, formalities for the creation of trusts. Chapter 3, the 3 certainties. Chapter 4, constitution of trusts. Chapter 5, secret trusts and mutual wills. Chapter 6, resulting trusts. Chapter 7, constructive trusts. Chapter 8, non-charitable purpose trusts. Chapter 9, charitable trusts. Chapter 10, appointment, retirement, and removal of trustees. Chapter 11, duties of trustees. Chapter 12, power of trustees. Chapter 13, variation of trusts. Chapter 14, remedies for breach of trust. Chapter 15, offshore trust derivatives and affiliates. Chapter 16, settler control, forced heirship, and asset protection. Continuing issues of the offshore trust regime. Chapter 17, confidentiality and the regulation of trust activity. Chapter 18, trust and taxation. And then we have the appendices. All right? The appendices and then the index. So we're going to go through this book. This book is going to teach us what I will call the statutory trust. All right? The statutory trust. So there are two types of trust. We have the statutory trust and we have private trust. So I'll say what we call the black trust as my mentor. He calls it the black trust, and the private trust as the white trust. So once you know the black trust, you will know the white trust by sight. So this book will more or less be covering the statutory trust. So we'll go through this book to get the initial foundation, and then we'll expand and contrast for the private trust. Then we have the table of cases. All these are case laws. That is very important. Very important. Pertaining to trusts. All these would have been matters that came up before the court as different trusts that existed between different parties. And for some particular reason, there was a breach of trust, or someone was unhappy with the administration of a trust, and they brought a suit against the trustees in court. And all these are case laws of different situations that we should get and read, so we will see the application and get the guidance from the learned judges on how to apply the trust and where the mistakes were made by the trustees or the beneficiary, as the case may be, or in the drafting of the trust instrument. So we can learn from the judges of the shortcomings of the trustees or the drafting of the trust instrument, so that we will not make the same mistake in drafting our own instruments. So case law is very crucial to truly understanding and overstanding trusts. This is where you truly learn about trust and how to operate and administer trust. So all these are nice case laws that cover different aspects and different principles. And remember, principles don't change. So once you learn the principles and you have that foundation, you have a very solid foundation. Learning the principles. Methods are many, principles are few. Principles don't change. All right? So all of these case laws here. Saunders versus Vautier is a nice one. All right, so that's the case laws. Now we have the table of statutes, and this is what I mean pertaining to statutory trusts. They mostly comply with statutory law. So most times statutory trusts are revocable. But we'll get into all that. For now, this is just for introductory purposes, just to get you guys exposed and get the knowledge of trust in your frontal lobe. Any questions pertaining to the introduction, discussions in critical to really comprehending and understanding. So now we reach chapter 1. So in my other video on trust terms, I would have covered the use, the definition of use, the definition of trust. So you all could check that out, and then in comparison to the definition, you could come back to this video and see the explanation of the different definitions. So the definition of use and the definition of trust. All right, so here we go. So this will be a slow going read. This will not be rushed. This will more or less be, as I say, an introduction. So we're gonna take our time and really read and internalize the information. So chapter 1, development and nature of trusts. The use. Why the use? Why they start with the use? Because the use predates the trust. And in my read on the Britannicas, I did the Encyclopedia Britannica. I have a read on trusts and trustees that goes into how the use came about and how they used it back in the 15th century and the 16th century, the 14th century. So you all could take a listen on that. The Encyclopedia Britannica, Trust and Trustees. We have that is an useful information. So what I did with that, or what my hope with that is to take you guys back in history and bring you back to the present, to make the whole puzzle clear in your mind, so you don't have any misconception, you don't have any misunderstanding, and you can stand in any forum and dive and express yourself pertaining to trust and uses and things like that. So the use. The law of trusts was developed by the Court of Chancery in England from medieval times. The medieval forerunner of the trust was the use. So the forerunner of the trust was the use, which arose whenever land was conveyed to A on A's undertaking to hold it to the use and benefit of B. Instances where land might be conveyed to A to the use of B were. All right. So what this paragraph is saying here is that the medieval times, the law of trust was developed in medieval times by the Court of Chancery, which was in England. The medieval forerunner of the trust was the use. This is what they called it, a use. Right? And a use, just like a trust, is a relationship. So I'm going to keep it as layman as possible. Right? For the beginners, for the ones who know getting into this knowledge, it's just a relationship. Right? And a relationship with functions and roles and duties and offices. It's just a relationship. Right? So the use was the forerunner of the trust, which arose whenever land, so here we're talking about real property, land, that's like we have agricultural land here, and let's say some of us, our parents in the Caribbean will have, might have a garden with plants, or they might have an estate with citrus and avocado and breadfruit, right? So land was conveyed to A. Conveyed means transferred, assigned, or delivered to A on A's undertaking. So A would have undertake or would have gave his word, accepted, bonded, gave his word, your word is your bond, to hold the land, hold it, the land, to the use to the use and benefit of B. So to the use means that so the land will still be farmed, the land will still be producing crops, and A would hold the land and B could still use the land, but it's no longer in B's name as the owner. So B gave the land to someone else to hold on it as an undertaking so that B could continue to use the land and B will not be liable for any payments of taxes or any incidents, fees or fines or anything like that on the land. So that is what the relationship of a use entailed back in the medieval times. So instances where land might be conveyed to A to the use of B were. Let's see why they would have transferred land in use. So A, where B, the beneficial owner of land, was about to go abroad on a crusade, it would be necessary for the land to be held by another person on his behalf who would perform and receive feudal services. So if B, the beneficial owner, the owner of the land who conveyed it to another to hold, right, to the use of B, if B was leaving to go on crusade, the other person would hold the land and continue to maintain it, keep it clean, reap the crops, sell the crops, and keep the money, save up the money for B when B returns from the crusade. So that was one of the reasons that land would have been put into use. The second reason, where B was a community of Franciscan friars who were prohibited by their vows of poverty from holding property. So Franciscan friars were people back in medieval times who were prohibited by their vows of poverty. So they vowed poverty, meaning that they vowed to not have any property, have any money, have any bank accounts or anything like that. Something like monks. Like how you see monks in certain places that they just in the temple and they meditate and things like that. Franciscan friars were something like monks. So they took a vow of poverty. So if they had land before they took the vow of poverty, they would transfer the land into use, convey the land into use, and took their vow of poverty, so they no longer hold the land. And the third reason was where B was afraid of forfeiting his land on account of conviction for a felony or of losing it to his creditors. So the third reason, if B committed a crime in medieval times, you get convicted, they take the land from you. So in medieval times, you get convicted, they take the land. Or let me say, you borrow money from somebody and you're owing them, and you're realizing that you will be unable to pay your creditor. You will try to put the land into use, into somebody else's name. You no longer own the land no longer in your name. So when the creditors come to collect the debt, they can't attach your land or they can't claim your land because it's no longer in your name. So this was another way to another reason how that they used to use the use. Whatever the purpose for which a use was created, the common law did not recognize any rights in B at all, but regarded A, the holder of the legal title, as alone beneficially entitled. So under the use, common law, or what we call at law today, because common law today is statutes. That is what is common. That is what everybody in Trinidad here using as the law. Right? So common law in medieval times did not recognize any rights in the beneficiary or in the one that put the land into use. So they regarded the one that holding the legal estate, the one that holding the land, who had the undertaking to hold the land, they regarded the one that holding the land as the alone beneficially entitled. So only common law only saw the one that hold the legal estate or the legal title as the only one beneficially entitled to the land. They did not recognize B. Just like in today's system or in today's world, you hear 9/10 of 9/10 is possession. You don't ever hear about the 1/10. So 9/10 is legal title, the one who has control, physical possession of the property. So common law did not recognize the rights in the beneficiary. So therefore, if A brought an action at law, his legal title, and with it his right to possession would be upheld. So if if A, so A is the one that holding the land, A is the one who the land was transferred to hold in use, right, for the beneficiary, for the benefit of B. So if A brought an action at law, so let's say A sued someone in court for a breach or for unpaid claims or unpaid debts, his legal title and with it his right to possession would be upheld. So his claim will be upheld that he has possession and right to possess. His claim will be upheld in common law or at law. The Court of Chancery, so they're showing you here that there are two separate courts. We have at law and we have the Court of Chancery. And they still exist today. All right? But we'll get into that in another video. The Court of Chancery, on the other hand, regarded it as unconscionable that B should be excluded, and although it would not deny A's legal title, it would act in personam against A by issuing a common injunction restraining A from enforcing or exercising his legal right. So at law, the legal title is recognized in A. That is under the common law. And at law, the beneficial title is not seen or not recognized. In the Court of Chancery, on the other hand, they regarded it as unconscionable that B, the beneficiary, should be excluded. So remember, we're talking about medieval times. This is in medieval times. So the Court of Chancery came up and they said, no, it would act in personam against A by issuing an injunction restraining A from enforcing or exercising his illegal right. So now in personam is a Latin term for in person. So the equitable title or the holder of equitable title in Chancery could act against A, the one who holding legal title, in personam. So A now is responsible personally to the one who will enter equitable title. Failure to obey such an injunction would be punishable by imprisonment for contempt of court. So if the court passes an injunction, so you have an injunction you have different types of injunction. You have injunctions to do something and you have injunction not to do something. Right? So if the court passes an injunction that the trustee or the one who holds a legal title is not to sell the land, and the trustee sells the land, then the trustee could be held in contempt of court for selling the land. Right? So he will be personally liable to the beneficiary and will be in prison for contempt of court for failing to abide by the injunction. So we'll get into that aspect of trust in later dates and later videos, not publicly. We'll have to do those. We'll have to discuss those things privately. So we'll discuss those things in later videos, all right? By this method, the Court of Chancery would ensure that the rights of B, the beneficiary, the equitable owner or seteki use, this is pronounced seteki use, or beneficiary use, would prevail over those of the legal owner or fioffi to uses. Fioffi is trustee in today's terms. So you notice they're giving us the information in this short paragraph, this short section right here, from right here to right here. Look at how much information is packed in this short paragraph right here, and this is still not clearly for the layman to comprehend, right? But it is not difficult to understand as long as we learn the definition of these terms, these Latin terms. So in personam, we went from beneficially entitled to equitable owner to setike use. We went from A's undertaking to the use of and benefit of B to forfeiture uses, right? So the forfeiture uses is the trustee. This is A. This is the one who holds the legal estate, the legal title, or the legal owner, right? We have the equitable owner, the one who holds the equitable estate, the equitable title, or the setike use, the beneficiary, right? Employment of the use in medieval times made it possible to avoid some of the burdensome feudal incidents to which the holder of the legal estate was subjected. So feudal incidents, so they use the term incident even in the Britannica, where I covered trust and trustees on the history of uses. They use the word incidents. Incidents means fines, fees, levies, taxes, liens, things like that. So employment of the use in medieval times made it possible to avoid, in today's time, the wealthy, the people who know about trusts and estates and have this knowledge, they use these entities to avoid or mitigate their tax exposure because it is totally legal to avoid taxes. It is illegal to evade taxes. There's a difference. All right. And so employment of the use in medieval times made it possible to avoid some of the burdensome feudal incidents to which the holder of the legal estate was subjected. For instance, under feudal law, the lord was entitled to a substantial payment called relief when an heir succeeded to feudal land. And if there was no heir, he was entitled to recover the land absolutely called escheat. So I'll read that again. Let this part sink in, because as I say, we're not rushing it. Taking your time. I want to get a dictionary open so we could look at some definitions. Right. So we're going to look at some definitions. So when we finish this read, we're going to go through the dictionary and we're going to pull these definitions and see what these definitions are. It is important to read this information with a dictionary, preferably the Black's Law 8th edition, so that you can get a clear comprehension of what it is the information is telling us. Employment of the use in medieval times made it possible to avoid some of the burdensome feudal incidents to which the holder of the legal estate was subjected, the feoffee or the trustee, the one who holds the legal estate. For instance, so now they're going to tell us what was these feudal incidents. Under feudal law, the lord was entitled to a substantial payment called relief when an heir succeeded to feudal land. So when someone succeeded to feudal land, an heir, there is payments to be made or relief to be made to the king, or what we call in today's time inheritance tax. And if there was no heir, so if there was no one to succeed to the land, the king was entitled to recover the land absolutely called escheat. Such consequences could be avoided if the land were vested in a number of feoffees to uses, trustees to use, for they were unlikely to die together or without heirs. So what was happening back in medieval times, in order to prevent escheating and relief and these substantial payment, inheritance taxes, feoffee to uses was used. Multiple feoffees were used. So the land would just keep transferring from feoffee to feoffee. So that could happen until the king who in power at the time passed away. And go on so generation after generation. And no payments of inheritance tax would ever have to be of, or incidents or relief would ever have to be paid. For they were unlikely to die together or without heirs. And those who died could be replaced. Again, where land was held by a minor tenant, the Lord had the right to choose his marriage partner. The incident of marriage, and if the tenant refused the person chosen, he was liable to pay a fine to the Lord. So where land was held by a minor, so if someone was a minor tenant, the Lord had the right to choose his marriage partner. So the Lord could have chose someone to get to marry to the minor tenant. This is the incident of marriage. And if the tenant refused the person chosen, he was liable to pay a fine to the Lord. So if he refused to marry the person chosen, he had to pay a fine to the Lord. By vesting the land in a number of adult feoffees to uses, the Lord would be denied these rights. So if the Lord chose a marriage partner, this is how they would have created these different legislation and things back then, right? They would have created in such a way that they create a situation where they put you in a position where if you fail to do what they say to do, they could get your land, they could get your property, they could get your wealth. It was diabolical. Look at today. Look at the world we live in today. By vesting the land in a number of adult feoffees to uses, the Lord would be denied these rights. Lastly, it was possible to avoid the common law rule that freehold land could not be devised by will, by vesting the land in feoffees and declaring the uses upon which the land was to be held after the testator's death. By this method, effective dispositions of equitable interest in land could be made on death. So the uses even surpass, or it was even much more powerful than a will. They use the use to pass land and pass vest land into feoffees and declare uses upon it. So the land was held after the testator's death. All right. So that is an introduction to use, a full compact introduction. So let's go now. Let's go and look up some definitions now. So we're gonna start. So the law of trust was developed by the Court of Chancery in England from medieval times. Court of Chancery. So let's look up Court of Chancery. What is a Court of Chancery? So this is the Black's Law 8th edition. This is a book by Brian A. Garner, right? So let's see if we can find Court of Chancery or Chancery Court. So you could go on Google and search for this book and you should find it. All right? Black's Law Dictionary 8th edition. So Court of Chancery. Mm -hmm. Mm -hmm. All right. So let's search Chancery now. So let's go to H, search Chancery. So let's look up chancery. Chancellor. Chancery. Chancery court. All right, so let's see chancery. A court of equity. You all seeing this? Let me make it a little bit. Zoom it up a little bit. All right. So we're reading here. So chancery, a court of equity. Collectively, the courts of equity. Chancery, a court of equity. Collectively, the courts of equity. The term is derived from the court of the Lord Chancellor, the original English court of equity, also termed court of chancery, chancery court. Chancery's jurisdiction was complementary to that of the courts of common law. It sought to do justice in cases for which there was no adequate remedy at common law. It had originated in the petition, not the writ, of the party who felt aggrieved to the Lord Chancellor as keeper of the king's conscience. In its origins, therefore, Chancery's flexible concern for justice complemented admirably the formalism of a medieval system of common law which had begun to adhere strictly, perhaps over strictly on occasion, to prescribed forms. So common law was strict on the form. Cross your T, dot your I, the letter of the law. It had no conscience and common law. By 1800, however, Chancery's system was itself regarded as being both consistent and certain. This is a quote from A.H. Manchester, Modern Legal History of England and Wales, 1750 to 1950, 135 to 136, 1980. So this is taken out of this text here. So this is what Chancery Court is, a court of equity. All right. So we could read it different now. We could say the law of trust was developed by a court of equity in England from medieval times. The medieval forerunner of the trust was the use, which arose whenever land was conveyed to A on A's undertaking to hold it to the use and benefit of B. All right, so the next definition we're going to look at is trust. So we're going to look at trust. Let's look at trust. So we go down to T. T. TRU. So we look at the definition of trust. We're going to look at the definition of use. All right. Trust. Noun. Trust. Trust. The right. Enforceable solely in equity. And remember, court of chancery is a court of equity. So if a trust is the right solely enforceable in equity, then a trust is only recognized in equity. The beneficial enjoyment of property to which another person holds the legal title A property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiary. So in medieval times, this would have been a use. So it would have been a use. And the beneficial enjoyment, this would have been the seteke use. The beneficial enjoyment would have been the seteke use. The trustee would have been the fee of to use. The settler would have been the fee offer to use. And as I said, the beneficiary would have been the seteke use. Right? So this is how in modern times now the terms change, but the definitions remain the same. The word change, but the definitions remain the same. So feudal times still exists in modern times. We still live in the Roman Empire. The Roman Empire did not fall. The Roman Empire rose. It still exists today. And this is how you can see it for yourself. Remember, no one can be told what the matrix is. You have to see it for yourself. So for a trust to be valid, it must involve specific property and reflect the settler's intent and be created for a lawful purpose. The two primary types of trusts are private trusts and charitable trusts, or private trusts and public trusts, or private trusts and statutory trusts, right? So this is why I told you guys that in the Commonwealth book, we're going to be learning about statutory trusts. But once you learn statutory trust or charitable trust or public trust, you can compare and contrast, and it will be much easier to understand and comprehend the private trusts. All right. So that's the trust. The next definition we're going to look at is the use. All right. Let's see what we get under use. USA, USC. Use. Noun. The application or employment of something. Land conveyed to the fee of fee, especially a long continued possession and employment of a thing for the purpose for which it is adapted, as distinguished from a possession and employment that is merely temporary or occasional. When the fee offer, or when B grant the land or convey the land to A, when B is going on the crusade, and the crusade used to last for years, so that's a long continued possession and employment. And then A would employ the land and collect monies and collect rents on behalf of B. So when B returns from the crusade, B will get all these money that was collected. So as distinguished from a possession and employment that is merely temporary or occasional. The neighbors complained to the city about the owner's use of the building as a dance club. So temporary and occasional talk about like a building that is just used for like a dance club. A dance club every month you might do something in there. All right. You have accessory use, you have adverse use, beneficial use. So beneficial use, back in the medieval times, they call it seteke use. Property, the right to use property and all that makes that property desirable or habitable, such as light, air, and access, even if someone else owns the legal title to the property. And we spoke about that in the explanation. The fee of fee to use was held legal title, and B, the seteke use held the equitable title, and they had the right to use the property. So they could go on the land, they could plant the land, they could reap crops from the land and sell the crops and things like that. But the legal title was in the fee of fee to use. You have collateral use, conditional use, double use, exclusive use, right? Experimental. So we're going to go through all those definitions when we're going through definitions, right? When we're going through definitions. So the other definition we're going to look at. So you guys know, you understand the court of chancery. You understand what our trust is, what our use is. Let's see what Franciscan friars are. Any other definition here? Franciscan friars. Let's see what Franciscan friars are. Let's see Franciscan friars. Franciscan friars. Let's get correct spelling. Franciscan. C. Alright, so I don't think it's here. So we don't have the definition here, right? CIS, right? Alright, so let's see if we can pull the definition up on Franciscan friars meaning. So we have some pictures here of Franciscan friars, the men who take a vow of poverty. So a Franciscan friar is a member of a religious order called the Order of Friars Minor, founded by Saint Francis of Assisi over 800 years ago. Men who take the vows of poverty, chastity, and obedience seek to follow the manner of the life of Saint Francis, the manner of life that Saint Francis led. So that's a Franciscan friar, one who follows the life and manner of Saint Francis. Right? So that's a Franciscan friar. Right? Right. So we know what a Franciscan friar is, right? Who took the vow of poverty. And let's look at all right, so let's look at let's see in personam. Let's see in personam. In personam. In personam. In personam. Around the column here. What? We're gonna jump back up. Right. In personam. Right. In personam jurisdiction. In personam judgment. In personam. So Latin. So it's Latin, it's a Latin word. It means against a person. All right? So in persona means against a person. So when so it said here that the court of chancery or the court of equity on the other hand, regarded it as unconscionable that B, that is the beneficiary, should be excluded, and although it would not deny A's legal title, the trustee's legal title, it would act in personam against the person, against A by issuing a common injunction, restraining A from enforcing or exercising his legal title. All right? So let us check out now. We got these. Relief. No, let's check out seteke use. Seteke use fiofita uses. Seteke use fiofita uses. Seteke seteke use. Seteke use. Seteke use. Seteke use. Seti key use is archaic. Archaic, meaning it's of old. The person for whose use and benefit property is being held by another, who holds the legal title to the property. All right, so that is seteke use. So let's check out fiofita uses now. Fiofita uses. They're changing words on us, guys, but the definitions remain the same. Once we learn the words that they change, we'll see it as it is. Fiofi. Right. Fiofi. Fee simple. Fee farm. What? Oh, my bad, guys. E.O. All right, we get it there. Fee of fee, fee of fee, fee of fee. Right, fee of e, fee of fee, fee, fee for, fee for, fee for, fee for, fee fee, fee of e, fee of e. The transferee of an estate in fee simple, the recipient of a fief. Fiofita uses. History. A person to whom land is conveyed for the use of a third party called a seteke use. And we just saw what a seteke use was. One who holds legal title to land for the benefit of another. A seteke use, grantor uses, trustee. So you see how in modern times now it changed from fiofita, trustee. All right? All right, let's see what fiofment is. The act of conveying a freehold estate, a grant of land in fee simple, also termed fiofment with livery of ceasing. The land so granted, the charter that transfers the land also written en fiofment. Also termed deed of fiofment. Cases deeds. So when you see fiofment, when we go on when we go to a attorney or a lawyer, and they create a deed to register in the county. So what is a deed? Deed of fee of ment. A deed is a fee of ment, right? So we have 1 cent, we have a second sense, and we have a third sense of the word, right? So when you see these numbers on the words, that is 3 different definitions for the word, right? Right. So what is the next word we're gonna look at? So let's go and look for relief. Relief. Let's see what relief is. Talk about relief. The king get relief. What they call relief back then. Relief. 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 A payment made by an heir of a feudal tenant to the feudal lord for the privilege of succeeding to the ancestor's tenancy. You hear that? So you're an heir. You succeed into your ancestor's tenancy, and you have to pay a fee for inheriting something that belongs to you. No wonder, no wonder our ancestors created uses and trusts. And we not using these things today? Come on, guys. Come on. Come on, guys. Trust and estates. Yeah, that's the way to go in everything. It's a way of life. Don't worry, you'll see it. Relief, a payment made by an heir of a feudal tenant to the feudal lord for the privilege of succeeding to the ancestor's tenancy. So succeeding to your ancestor's tenancy is considered a privilege. A privilege of the feudal lord. Alright? So that's relief. The other word was escheat. So let's see what escheat is. Let's see what escheat is. Escheat. 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 History. The reversion of land ownership back to the lord when the immediate tenant dies without heirs. So if you have land, think about it. Just think about it, guys. Think about it. If you have property in this modern time, be it your house that you would have worked for and acquire, be it your estate, your bank accounts, your NIS, think about it, and you don't create a will or you don't create a trust or a use to pass these property or these property on to your immediate heirs. Where does that property go? Think about it. So the reversion of land ownership back to the lord when the immediate tenant dies without heirs. Right? So that's a street. Right? So what any other definition? Minor tenant, incident of marriage. We understand incident of marriage is where the lord would have choose someone for you to get married to and you refuse, they had to pay a fine. We looked up the definition of fees. Well, all right, guys. So that's it. That's it for this first part of the development and nature of trust, the use. So as I said, you all could check out the reading that I'm doing with Encyclopedia Britannica on trust and trustees. It goes into much more detail on the use in the medieval times under the feudal in that feudal time with the addition of this recording here. with the collaboration of both, you will get a much clearer view on the use. All right. So thank you for your patience. Thank you for your time. Remember, guys, strength and pause. All right. Let's learn. Each one help one, iron sharpen iron. Let's grow in knowledge and be better than ourselves yesterday. Let's be better than yesterday. All right. So bless, strength and pause.